Hello and welcome to my YouTube channel where we share safe real estate investment tips, talk about property law, and share credible real estate investment opportunities here in Nigeria. Basically, every video on this channel is an asset to real estate investors and property buyers. Finally, on this channel, every subscriber is family, a family of millionaire real estate investors. Welcome.
They can, inherit the properties, and it's crazy down here. So this consciousness alone of where we are coming from is enough to, cheer somebody up to protect the future of your loved ones. It's very, very important. I like that you said basically all, and thank you so much for that explicit explanation on what a will is and the importance of having a will. So if anybody is here, please let's have comments coming in. Let me know if you are catching something from this broadcast. If you have questions, drop them in the comment section and we'll take them as soon as we are ready for questions. And then do also share this broadcast as you're watching and let someone else catch us live before we're done. Okay, so moving on to the next question. We are Mr. Raymond, please tell us, what are the demands of transferring ownership of a will? What are the demands?
Okay, now I'm going to break this down and put it into steps. Before we go to the steps of what is required before you transfer ownership of property by will.
Okay.
First, the owner of that property, the testator now. Remember I said the person that makes a will is referred to as a testator.
Testate, yeah.
Yeah.
This
so
testate or testator?
Testator.
Testator
is the person. The act, dying testate is the act. Okay. The testator is the person. All right. Okay. Dying intestate. Intestate is without the will, without making a will. Yeah. Intestate, you're right. Okay, so the testator must ensure that first he has bought genuine properties.
Okay. Whoa, very important point there.
If you have not bought genuine property, if you write the best will in the world, you are just willing, you are willing issues to your children, right? Because they would live with the assumption that this belongs to my father. And they would be ready to die protecting what they felt belonged to their father. So you must ensure that you had bought genuine property, and you importantly also have done good documentation for every property that you bought.
Okay.
Good documentation. What I mean by, because they are fathers with respect who bought properties. Those kind of times where you buy properties and they will throw stone from here to that point, from here to that river. All right. And at that point, there's no documentation. Now, when you make a will for those kind of properties, you may end up someone else who maybe has bought from somebody else and has established document. Because permit me to say this, I say this a lot on my YouTube channel. In law, in land cases, cases are determined on a preponderance of evidence. In summary, the courts in civil cases, particularly where land cases fall under, they weigh evidence. Now, if this guy comes and says, "No, my pa get am, it belongs to my father, it belongs to my father," all with his mouth, nothing to show. And the other guy comes and says, "It belongs to my father," he brings 5 documents showing, everything looks clean, genuine. It may not belong to this guy that has documents. But before the courts, if you are the judge looking at everything, the elements of proving of title and all of that, who most likely would you sway towards? It's the guy with the document.
The one with documents, yes.
In law, again, a document speaks for itself. So a lot of other factors that we look at, particularly the fact that documents. So importantly, haven't gotten genuine title, ensure that you do proper documentation so that when your children are looking at this thing, they don't need even a lawyer to explain to them. You understand that, oh yes, this is good stuff, right? So having done that, now you make a will. After making a will, you can properly now excuse everybody. I mean, die and go to heaven wherever you are going. Oh, please go to heaven, all right? Okay, now, when you go to heaven, title now flows. I'm saying this literally. Title now flows from you to those persons that you mentioned in the will.
Okay, this is another network interruption. Okay, yeah, I can hear you. You're back. You're back.
What was the last thing you heard, please? I want to make sure.
I heard you talking about title flowing to the next person who you are with the property.
All right.
When you die, title flows.
Yeah. All right. Literally, title flows from you immediately you die to those persons that you mentioned as executors in the will. You get that? Now, yes, for them to be authorized to now act, they have to apply to probate. That's the technical term. Just take it like that.
You are going to expand on that probate when you're done, though. Just go ahead. Go ahead. No, go ahead. Let's focus on what we're talking about.
Okay, I didn't hear what you said. We had network interruption. What did you say?
Sorry. Okay, we're talking about the probate thing. But don't worry, just flow. You can take that much later.
Okay. Yeah. Okay. So after the title flows, literally, the executors would apply to probate. Then probate will be granted to them. Probate will be granted. Immediately probate is granted, legally, they are now authorized to carry out important things or instructions as it relates to the estate. If they are done with every other thing, these things I just said there are a lot of technicalities, procedures, and in between. But as a way of communicating what we have in mind today, this is it. At the point, it is only at that point, after probate has been granted to the executors, that property can now move. Title can now be transferred to the beneficiary.
Okay.
At the point of making the will, only intention was expressed.
Okay.
That intention remains an intention till the executors transfer title to you through what is referred to as vesting deed or an assent. Through a vesting deed or an assent. That is when title can flow from the dead person to.
Means after you have drawn a deed with your lawyer, and upon your death, the person who you are trying to transfer that property over to has to go to court, or what?
The person you gave, not the person, is not the beneficiary doesn't have the work here.
Okay.
It is the people that the man mentioned in the name. I said that there are people who would carry out those instructions. Now there is the beneficiary. The beneficiary is the person who, for instance, I say, I give my property on the island to Mercy KK.
Okay.
In that context, you are a beneficiary.
Okay.
Now, in the same will, I will now further say, I appoint Mr. Godwin Philip as an executor.
Okay.
That person being referred to as an executor is the person that will carry out the instructions inside that will.
Okay.
So upon the death of the testator, responsibility now is upon the executor, not the beneficiary, Mr. Godwin. Responsibility now falls on Mr. Godwin to apply to probate.
Okay.
Having applied to probate and gotten a grant, he is now formally authorized to now transfer interest to Mercy Okeke.
To Mercy. Okay, that's clear.
You understand it?
Clear.
Now,
that's
if the man didn't make a will, if he died intestate, then the children, the wife, there are categories, there's hierarchy for it. Those ones would then apply to become administrators. But if the man made a will those persons he expressed as or appointed as executors will be the people that will apply to probate and thereafter transfer interest to the beneficiary, in this context Mercy Okeke. And it is only at that point that Mercy Okeke can sell a property. The Mercy Okeke cannot sell a property, and that takes us back to the question I was hoping you're going to ask, that question of whether a will is a title document. So in this context, I haven't looked at this particular issue or subject matter. It's not a title document.
Okay, so a will is not a title document. Sorry, you are talking about if a will is a title document.
All right, so with the explanation I gave earlier, you yourself, you will even agree with me that a will is not a title document. A will simply expresses the intention of the will maker, the testator. All right, and on the other side, a title document is a document that transfers interest, title, ownership from one person to another. If you have ever seen a will, you look at it critically and you look at a deed of assignment, any form of deed that transfers that, you would see the clear difference. All right, so in summary, a will is not a title document. It simply expresses the intention of the testator. While if there's a will involved, the document that transfers title is the assent. And if you see the assent, you also see there's always a reference to the will in the assent. With that, you would then properly transfer title. So until then, this is now a message, an important lesson or message for people who buy properties. Once you hear that there's a will involved, note that the fact that his name is a beneficiary in the will and the man wrote, I give Mr. Raymond or Mercy Okeke this property on the island, it doesn't empower Mercy to sell.
Yes.
What you need to see is the assent or the vesting deed.
Okay, the assent or the vesting deed. Okay.
Yes.
That's beautiful. Thank you. I am having a wonderful
time. Something I wanted to say here.
Okay, go ahead.
Okay, let me make this point here quickly before I forget it. Now, some persons this is Africa again, and most of us, especially when the first son and had access to the man's documents, the landed property, the documents rather, or the wife. Now, the fact that you are in possession of those documents, be them original, be them whatever, they don't make you the owner. Possession is not transfer of title. Possession of title document is not transfer of title. There must be documentary. Please, if there's one thing you are also going to take away from this beyond will, is the fact that I consider it the most important principle in most important legal principle in all real estate transactions. You must ensure that it's principle of nemo dat non habet. In summary, in summary, you cannot give what you do not have. So the fact that you are carrying a document doesn't mean it's yours, and you cannot properly or competently transfer title to another person simply on the basis of possessing the document. Your name has to be on it. Title has to be transferred to you documentarily, legally, before you can sell property to another person. So for property buyers, ensure that anybody coming on the basis of a will, now my husband is my father, I'm the first son, those things are English. Yeah. Those things are just, law is law. It's all right.
And this is basically the issue with local agents. This people we call them monile. This same issue with my father, my uncle that had it. No proper transfer, no proper allocation of who owns what, and that's why I see people fall victim of these local agents problems and all that. Thank you for pointing that out. Thank you so much. So anyone who got questions, you can drop them in the comment section. Let's know. Great. I can't wait to start willing my properties over to my child or my children, right? It's going to be an amazing process. When you think there's something about the law that gives you this confidence, this backing, this courage to do whatever you want to do, that protects you, right? We know that the country somehow is corrupt and all of that, but then if you understand the law and all of the power of the law and all of the provisions of the law. You can wield the law to your advantage, right?
It's a tool of creating solution and preventing solution.
Absolutely. I am loving this session already. So that's all the question I have on my list. But there's one question here in the comment section already. So I don't know, should I take that right now? You ready for that? If you have any questions, if you're here with us,
okay. That's all the questions you have, right?
Yes. But I have one question in the comment.
All right, so let me say something. Okay, let me just sort this out and I'll attend to those ones. Let me know I don't have anything to, so I don't forget. Now, back to, because this I see there are a lot of things in this that we've summarized in this session today that are way wider than they ordinarily are, and there are a lot of solutions that this can bring and problems that they can prevent. Now, outside making a will, because it sounded quite nice having the conversation about a will, but beyond that, there's this very large political family in Nigeria that I had the privilege of intervening in and indirectly intervening in their will issue. But the truth about it is that sometimes a will leaves a lot of issues, especially when the man doesn't do it the way I suggested earlier, that you should do it the good way and be human when doing it. Now, I have, in my opinion, other solutions, as it were, in ensuring that the goal, which is to ensure that your children are fine, your wife is fine after you die, and all of that, to ensure that the goal is achieved. Here's my other suggestions. Beyond making a will, if you know that your family is this very strong-willed one that no matter what, even if a will is involved, they would go to any point to ensure that they stress your wife and children with court cases for years. One of the things you can do is gift, especially if you are from that kind of area or community or family where ladies, your children, you know that if you die, your children are going to be disinherited. Now, what you can do in those instances is, before you die, gift your children the properties. Prepare a deed of gift and give them to your children before you die. Let them take possession. Do all you can. Your lawyer has to be smart in doing this. Ensure that you put in a lot of evidentiary, give it a lot of strength to ensure that this one, they're not be disputant, that kind of thing, and gift them to your children. Also, there are a lot of technicalities attached to this, but I'll just say it. When buying properties, you can as well buy property with your wife as a co-owner. The technicality or the technical thing around it is tenancy in common or joint tenancy. But I'm not going to go into those details. The point is, you can buy properties in the name of your wife, or buy properties alongside her, having in mind the technicalities involved and then the things that your lawyer should do in between. But some of these have a way of also taking care of your wife and your children, and if possible, maybe your relations as well before you die. That way, you are living peace. You have ensured that everyone is satisfied. Anyone that wants to be greedy just wants to be greedy. There's this, I'm not sure I have that time to tell that story, but in summary, that is what it can do for you. It reduces a lot of family issues, both internally and externally. Just sort out everybody when you are alive, and be sure that the documents are watertight and everybody is intertwined in the document, So that also helps to reduce the issues and sort your children out after you die.
Great. Thanks for that advice. Thanks for that. Personally, I would even go for that instead of the whole will thing is beautiful, but I think to be before what's the proverb? This prevention better than cure.
Yeah.
Something like that. So I think I like that idea. Thank you so much. I had a great time. I was smiling ear to ear. I love this session. So we'll just take one question that I can see here from Samson Oleg. Says, let me project his question. He says, Great work. Thank you so much. So what happens when a couple dies due to unforeseen circumstances and the kids are too young to manage the estate? In this case, what is done with the estate? Did you get that? What happens when a couple dies? So, for example, the couple died and their kids are very young, the children, they cannot manage the property at that time. What would be done?
If he made a will, and you see that also brings the importance of making a will. If he made a will before he died, then the executors have the responsibility to manage the man's estate till the children become adults, and then they will hand over. And then importantly, that's why it's important to the people you name as executors. It's important that they are trustworthy. They
very
are
important.
reliable, very important. They are trustworthy, they are reliable, and you'll be certain that they will obey your instructions to the letter. There's also fiduciary duty in it. That's legal. But the point is, they are supposed to be seen as sound, right standing individuals that would ensure that your interest will be served. That's it. That also now brings back the importance of making a will, whether you are 40 or you are 30 or you are 50. You don't have to wait till you are 90. That sorts your children out.
Yes. Thank you so much. Nigerians don't like to write wills. That's why this question is coming up. They don't like the will like that because they feel like, I am gonna die someday. We don't like a die conversation, right? So what other way, if there is any, what other way, let's satisfy Musa.
I guess that now goes back to what I said a moment ago, that if you're not out to make a will, then you should be smart enough to transfer title to your children. Recently there's this property Fortreal Rei Ltd were reached out to sell. Now this woman is very smart, very smart. I don't know who, maybe it's a lawyer, but kudos to whoever is the brain behind that idea. See what she did.
Okay.
She before she already knows that there's issue between herself and the husband, family, right? And yes, she owns the property, very good property in a very good location. So what she did, instead of leaving issue for the man and the children, but of course you know that this is Africa. The people expect that once properties are within a family, naturally they generally expect that it belongs to the man, right? Not knowing that the woman actually owned the property. So what she did was to set up a company and made her two children directors in the company. And thereafter transferred interest in the property to the company. Smart move. Very smart one. And when I felt this is good. So that is a way of preventing, as in very, preventing issues before they come. So law, that is why I keep saying it. I say it a lot. Law is a tool of law is solution itself. It's create solutions and it prevent solutions. It's another very large family. In fact, while preparing that document, I had to take a plain sheet to draw the family to very large family, but they were having issues. Or one of the elderly women in the family knew that when she died, she's the last standing person amongst the generation that acquired the properties. So the children, in fact, the whole families or the whole children from the great grandfather, they are all polygamous. One of them had up to 16 children. So you can imagine how large and the family was. What did she do? She looked at the choice properties that she knew were going to be issues. She now reached out to my boss at the time, and then we looked at the whole thing and looked at the best documents to prepare. I prepared that document designating those properties as family properties. And ordinarily, an individual cannot sell family properties. So having designated those properties as family properties made every individual from the family, all the gates, each of them, what I mean by gates is, maybe for instance, a man had 3 wives. So in law, they are referred to as 3 gates. All right. So one person, a representative or the most elderly from each of those gates, everyone signed amongst the whole family. So we brought all the families together. Everybody signed the document. That way, there is a heavy protection to those families, and everybody that signed is privy. And that way, you are reducing a lot of issues. The same strategy can also be applied. Gather the families together while you are alive when there is peace, because usually the trouble comes when the man dies. Transfer title to everybody, sort everybody out. So that summarizes it.
Okay, great. Thank you so much for that. This has been amazing. Guys, help me appreciate Barrister Rei one. Just say thank you to him. This has been an amazing session. It's been mind-blowing beyond what I expected. I listened to your YouTube video on this topic, but this one is much more, educating than the one I watched. So I'm not even watch all over again. I have a note. I've written down some things here. I learned a lot from this session. Thank you so much.